Thank you, Mr Acting Deputy President. Well, what an unstructured, irrelevant rant we've just heard from Senator Back, and I'm just going to calmly explain why nothing that Senator Back just said is relevant to the crucial question before this chamber and the crucial question that Attorney-General Brandis has consistently failed to answer over 2 days now in this chamber and 2 days preceding that in the public conversation in Australia. What the Bell Act did or did not do is irrelevant here. We all know what the Bell Act did. What the Attorney-General said or didn't say on behalf of the ATO is irrelevant here. What the Attorney did or did not do in terms of the Commonwealth joining the High Court case in regards to the Bell Act is irrelevant here. There are two relevant matters. Firstly, was a deal cooked up between the Commonwealth Government, the Commonwealth Liberal Government, and the Western Australian Liberal Government? Was a deal cooked up that the Commonwealth would either not challenge the legislation in the High Court, the Bell Act, or not join a challenge to the Bell Act in the High Court, or not run a particular argument against the Bell Act in the High Court? That is the first question, and we know the answer to the question because Dr Nahan confessed it in the Western Australian Parliament when he said very clearly there was an agreement between the Western Australian Government and the Commonwealth Government for the Commonwealth not to oppose the Bell Act. So we know the deal was cooked up because the Liberals in Western Australia have confessed on the record in the Western Australian Parliament that a deal was cooked up. So for Senator Brandis to come in here yesterday and say, oh, from his viewpoint there was no deal, doesn't stack up. Now, just to be clear, the Greens don't make an allegation that Senator Brandis was involved in cooking up the deal. That, I have no doubt, was done by former Treasurer Joe Hockey and the Western Australian Government. Where Senator Brandis comes in is because he got tapped to give effect to the deal. He got asked, almost certainly by former Treasurer Hockey, to instruct then Solicitor General Gleeson to not run a particular line of argument in the High Court case relating to the Bell Act. And that particular line of argument, of course, was the Section 109 argument in the Constitution, ultimately the one that Mr Gleeson did run in the High Court and the one that the High Court agreed with to the extent that they voted 7-0 to strike down the Bell Act. It was an open and shut case. The Bell Act was clearly unconstitutional. Anyone with a modicum of legal knowledge could have seen that, and that's why the deal was stitched up. And Senator Brandis has consistently refused to answer that question. That is the substantive, most serious allegation before him, and I've asked him on multiple occasions in this place. Senator Watt has asked him on multiple occasions in this place, and he has refused to answer. He's either talked about something else entirely, as he is wont to do consistently, or he's drawn the veil of legal privilege down and said, I'm not going to answer that because it's legally privileged. Well, this Attorney-General is the most selective user of legal privilege I've seen in my political career, and that is saying something because I've dealt with people like Paul Lennon in the Tasmanian Parliament who used to use it all the time, as does the current Liberal government in Tasmania. But Senator Brandis is quite happy to waive legal privilege when it suits him politically, but of course when it suits him politically to claim legal privilege, that's exactly what he does. So we voted today, this Senate, quite comfortably, to send this matter to an inquiry, and it's worth pointing out that the motion actually compels the attendance of Senator Brandis and also Senator Cormann, who of course was the cigar-smoking mate of Joe Hockey and Finance Minister at the time that this sordid affair went down. So I look forward to this Legal and Constitutional Affairs References Committee inquiry. I believe that we will have the opportunity to once again ask these questions, and we will find out whether the Attorney-General believes in the rule of law in this country and whether he is a fit and proper person to hold that office.